I'm Phil Glennon, the video archivist for the city of Tega Cay. In order to preserve the history of Tega Cay, I have compiled a documentary, and with those interviews plus a few other supporting documents which we portray, we try to give you the real story of Tega Cay. This is the Honorable John Spratt, Congressman from the 5th Congressional District of South Carolina, to the House of Representatives. Before ending, Mr. Spratt was deeply involved in the settlement of the Catawba claim with the Indians. Mr. Spratt, you spearheaded the settlement of the Catawba Indian claim. Would you describe your involvement and the implications regarding the economic health of this area?
Well, I was involved in 3 ways. First, before I was elected to Congress, I was a named defendant. I was one of the property owners who was named in the complaint filed by the Catawbas initiating their suit. Secondly, as county attorney at that time, I was involved in orchestrating the defense to the suit by private landowners, but also by governmental entities. We put together sort of a consortium, York County, Rock Hill, Fort Mill, and Lancaster County, and together retained counsel to represent us, a firm in Boston. And because of my experience with the claim, when I was elected to Congress and took office in January of 1983, this was a matter of some concern to me. Initially, the claim was brought, not a lot of credence was given to it. It was pretty preposterous, the notion that a tribe of Indians which no longer legally existed could lay claim to 140,220 acres of land, 225 square miles, including all of Tega Cay, all of Fort Mill, all of Rock Hill, Carowinds, probably the most well-developed part of York County, and all of Indian Land Township in Lancaster County. But it quickly became apparent that this claim had some merit to it, because there were Supreme Court decisions coming out of New York State and Maine which indicated that these claims could not be scoffed at. There was something called the Indian Non-Intercourse Act of 1790, adopted when George Washington was president. In fact, it was adopted by the first Congress and a president who knew something about Indians, and the purpose was to separate white settlers from Indians so that white settlers wouldn't be poaching on Indian territory and creating problems that the militia had to come in and clean up. The Indian Non-Intercourse Act said that you could not buy land from Indians unless that transaction was ratified by Congress. In the case of South Carolina, the Catawba area was set aside to the Catawbas by the British government after the War of 1763, the French and Indian War. The Catawbas were the only one of the southern Indian tribes that had supported the British. In fact, they had sent a party of scouts to assist Washington on his route to Fort Duquesne. He recorded that in his journal. So they had a claim to some kind of remuneration after the war was successfully ended, and the British gave them a tract 15 miles square, which was surveyed off by Samuel Wiley in 1763. They had lived in this land for some time, but during the Revolution it became no man's land. This was where the new acquisition militia mustered. As a result of that, many of these men in the militia and otherwise got to know that there was land available here, and after the Revolutionary War they began an effort to acquire this land by leasehold from the Indians. As it turns out, my forebear, Thomas Spratt, was the first substantial leaseholder in this territory. He leased land from the Indians in the late 1760s and was in possession during the Revolution. But others followed his example after the Revolution, and by the turn of the century, the tribe itself was pretty well decimated by several bouts, bad epidemics of smallpox. It had never been a agricultural tribe, really. It was more of a hunting and fishing tribe living along the river, and so they tended not to be settled over the whole tract of land that they had, and they began leasing out large parts of the territory, and it was pretty much gone by the early 1800s. There were all kinds of efforts in this area to get the state to buy the land from the Indians, and that finally culminated in the Treaty of 1840, the Treaty of Nations Ford in 1840. The state of South Carolina entered into a treaty with the Catawba Indian tribe, gave them a sum of money payable over several years, promised to buy a tract of land for them, and in return for that, the Indians ceded title to their reversionary interests in all of this property that they had leased out and anything that they had left in their possession. The problem with that treaty is it was subject to the Indian Non-Intercourse Act, which nobody seems to have heeded at the time. And for years thereafter, the Indians asserted that they had a claim that was not validly enforced. They even took it to litigation in the early 1900s. Their attorney was, after working on it for 2 or 3 years, was prepared to bring a suit, and he died. And it lost all of its momentum then. In the 1930s, the congressman from this district, Dick Richards, was very sympathetic to the Indians. He was from Lancaster County. And he began an effort to try to see that they got more than the scrubby piece of land, 640 acres, the state had given them in 1840. He obtained for them around 4,000 acres of land, which they settled upon under a memorandum of understanding. They didn't become a recognized tribe then, but they had a recognized relationship with the federal government, got some benefits from them, were settled on this piece of land. The problem was it was collectively owned and held. It couldn't be subdivided and split up among them so that people would have plots of land they could live on, mortgage and borrow against, farm, what have you. And so that led to the feeling in the tribe that they'd be better off if they partitioned the land among themselves, sold some of it in kind, took the cash and spread it out, and partitioned the rest of the land in kind. That was done in the late 1950s, early 1960s, and the tribe then was terminated completely by an act of Congress. That was the principal defense in this lawsuit, that the Catawba Indian tribe really was not a tribe because it had been terminated as a tribe and therefore didn't have the protections of the law such as the Non-Intercourse Act. This case lasted for 17 years from the time it was asserted in the mid-1970s until the time it was finally settled by an act of Congress. It went from the district court here in Rock Hill to the Fourth Circuit Court of Appeals in Richmond, to the Supreme Court, from the Supreme Court back to the court in Richmond, from the Richmond Court, the Fourth Circuit Court of Appeals, down to the Supreme Court in Columbia, back to the Fourth Circuit Court of Appeals, back to the Supreme Court, and then down to the District Court again for trial. It was burning up enormous amounts of time, and in the meantime, property owners in areas like Tega Cay, Fort Mill, and Rock Hill were finding their property impeded. It was difficult to sell property in some cases. If you had a single family home in a recognized subdivision, it was not too difficult, but it was always a fuzzy cloud hanging over the property. And if you had a large undeveloped tract of land, as some of my friends and clients did, you found out that you couldn't borrow big sums of money against it because you couldn't get title insurance. One prominent case here in Rock Hill of someone who had the next big regional shopping center from Rock Hill lined up. He thought he had a title insurance commitment. The title insurance company itself didn't have adequate reserve to back up the commitment, and he lost the entire project. That was how serious the claim was. It was a real cloud upon this area for a number of years, and most people who didn't have to deal in real estate didn't quite appreciate the severity of it. We were also affected by the fact that in neighboring regions, when someone wanted to look at York County for development, for industrial location, the location experts and realtors and brokers would tell them on the sly, well, it's not clear that you can get good title in York County. They tell them about the Indian claim, and since there are plenty of other things to look at, it was an instant and easy way to turn people off this area. It was having a real impact on the development of property in York County, and Tega Cay was especially affected. Unfortunately, in the case of Tega Cay, this claim was filed and began to become binding and serious, and the suit was established at about the time interest rates were going up, and Tega Cay's original developer was having a hard time meeting its obligations under a mortgage with Chase Manhattan Real Estate Investment Trust. So the convergence of these two events, high interest rates in the mid-70s, plus the cloud on title by the Catawbas, was a real problem for areas like Tega Cay. Well, when I got to Congress, I knew that only one entity, Congress, could ultimately settle this because of the amount of money it would take and because there had to be a federal law in order to finally and forever dispel this claim, settle it, cancel it forever. The problem was I was the defendant in the lawsuit. The problem also was that the original effort to negotiate a settlement had started at the local level. Local legislators, a legislative delegation, had gotten together a committee and they had attempted to negotiate a settlement. They had a draft outline of a settlement and voted upon certain terms of it, and the vote was something like 5-4 not to go forward with the negotiations. As a result, a suit was brought and they never got those negotiations up and going again. We had several meetings, a couple here in this office, where I urged them to see if they couldn't pick up the ball and get it moving again, but there was not a consensus there, and there was a feeling anyway that unless there are federal funds available, what we may be doing, even if we accomplish a settlement, is for naught. So finally, after 4 or 5 years, and finally after a Supreme Court decision, the first trip to the Supreme Court, telling us exactly where the parties stood, we were able to begin in earnest settlement negotiations. Until then, the Catawbas could claim that they have valid title 140,000 acres, an enormous claim. After the Supreme Court decision, it was substantially whittled down. The court in effect held that if you lived continuously on this property since 1963, for 10 years continuously, you could establish a title by adverse possession. Not everybody could do that. Not everybody in Tega Cay could do that. But nevertheless, that was a defense that diminished the claim and at least got the ball back in the ballpark where we could start to negotiate. Frankly, one of the problems I had in taking up the negotiations was that I was the defendant in the lawsuit. The Supreme Court's decision pretty well eliminated any claim against me, but I had to go back, file for summary judgment, establish my position. I still had a small tract of land affected by the claim. Not all of the land that I held was free and clear. So I went to the Ethics Committee of the House and said, I've got this problem. I owe an obligation to my people in York County and Lancaster County to clear up this claim. It's a big problem. It's an expensive problem. I probably know more about it than anybody else. I'm in the best position to do something, but I have a conflict. Can you tell me how I should handle this? And the Ethics Committee, after studying the matter for some time, gave me an advisory opinion saying, you should disclose to everybody your interest, but it's been recognized often in the past that a member of Congress has an overriding, overwhelming duty to give his constituents effective representation. And in your case, your interest is such that your duty to render effective representation to your constituents overrides that and takes precedence. So you can go ahead as long as you make clear that you have something of a stake in the outcome of the case, which I did in every case, studiously, usually in writing to make it absolutely clear. So we began the negotiations. I had been in touch with the Indians' attorneys before I was elected to Congress. We renewed the contact afterwards. I knew Don Miller well. I knew that he would like to negotiate, so we broached the negotiations, sat down and began to negotiate. It soon became clear we needed some sort of formal structure, so we approached Governor Campbell. Fortunately, Governor Campbell had talked to this matter, had been talked to by someone by the name of Crawford Clarkson, a wonderful person who was a tremendous resource to us. He was the chairman of the State Tax Commission, a CPA from Columbia, a really public-spirited chap. And he had, by chance, had a conversation with one of the Catawba's lawyers from Columbia by the name of Jay Bender. Jay Bender told him all about this case. Well, the governor had to sign every year a certification to bondholders, mainly on Wall Street, New York, about South Carolina's liabilities, including its contingent liabilities, and Crawford Clarkson had to write the section that dealt with the Catawba suit. He was trying to get his hands around it, figure out how big a contingent claim it was. And as he got into it, he appreciated the gravity of it, and so he began to convince the governor that the governor himself needed to get involved in it. And I went down on Labor Day weekend in the mid-1980s and sat down with the governor, and we spent about 2.5 or 3 hours that evening kind of conceptualizing how we would settle this thing. The governor was good enough to write Manny Lujan, an old colleague of his in Congress who was the Secretary of the Interior and solicit his participation. I'd already been in touch with him. They had said they'd participate, but it helped to have that letter from Carroll Campbell to an old colleague, Republican colleague, Manny Lujan. So Lujan at the Department of Interior agreed to send a delegate to the negotiations, and therefore we had the state, we had the federal government, we had the Indians and their lawyers, we had the local government representative with Senator Hayes, and we took it from there. It took us 5 more years to negotiate the final settlement and get it passed in Congress. It was an arduous negotiation, believe me. We used every kind of pressure and leverage we possibly could. And we continued to go through the court system. In fact, the Catawbas went back to the Fourth Circuit Court of Appeals and in effect got an adverse opinion which once again sort of sobered them up and made them realize that their claim was not as great as they were asserting. That helped us bring them back down into the range of an acceptable sum of money. They wanted $125 million. We didn't see how we could possibly get $125 million. We ultimately settled it for a little over $60 million, about half what they originally sought. And more than 2/3 of that came from the federal government, which I regarded as a bit of a coup because the federal government really had no liability or responsibility except for the fact that over the years, notwithstanding the Non-Intercourse Act, notwithstanding the pleas and complaints and inquiries from the Catawbas, the federal government had done next to nothing to help their case. In fact, it had seen to the passage of legislation which inadvertently, in the 1960s, almost wiped out their case. So we had a good, equitable claim against the federal government for malfeasance of the Catawba's affairs when the government stood in a trust relationship with them. And we were able to use that argument to extract money from the federal government. Ultimately, I was able to settle it because I helped put through the Clinton budget in 1993, not a popular budget around here because of the tax increases, frankly, but had it not been for my key assistance in helping Leon Panetta, who was then at OMB, put that budget together, I never would have gotten the money commitment out of Leon Panetta to put up the federal share of the settlement. I'll tell a little story about Tega Cay. We were trying to get money from every possible source to settle it. Duke Power Company had a great interest in settling it because it had so much land owned by Crescent Land and Timber Corporation, ripe for development with this big cloud on it. That's a good example of how bad it was when Duke didn't have a cloud to clear the cloud and couldn't develop property. That tells you how serious a claim this was. Where Duke said, to get rid of this nuisance, we'll put up $500,000. If other people will match it, we'll put up $500,000 in matching money. And we'll throw in another $500,000 of our own money towards the settlement. One of the entities that we thought should pay something were the title insurance companies. When Tega Cay was developed, the developers had the foresight to obtain title insurance from the Chicago Title Insurance Company, and I believe everybody who bought one of the original lots got a title insurance policy from Chicago. We wrote Chicago, reminded them of this. They took pretty much of a stonewall position. We then got the Duke Power Company to write their title insurance company. As a result of the Carowinds claim, they had an interest in the Carowinds land through Crescent, and tell them that if they didn't settle this suit, and if they lost more than their coverage, they would sue them for the difference. We got the Tega Cay Town Council to do the same thing. I drafted the letter, as a matter of fact. We sent it to the title insurance companies, and it said, if we lose more than our coverage on this property, we're going to sue you for neglect and negligence in the settlement of the lawsuit, which you had an obligation to provide us a defense in. That got the attention of the title insurance companies. I met with them at the Sheraton Hotel all of one day, about 2 months later, and we got $1,700,000 out of them ultimately. That was the way we settled it, put the pool together. We went to the counties, we went to the state, we went to private entities, got out and raised the money, literally put a campaign fundraising effort together here in my office and went out and raised over $1 million in private sector contributions to put the pot together. It took 5 years of my time to do it, but I have to say it was one of the most gratifying achievements of my own career. Partly because My forebear, Thomas Spratt, had been one of the original settlers. I was glad to bring this to what I thought was an equitable and fair conclusion. I think old Thomas Spratt would have been pretty proud of it too.
I thank you, Mr. Spratt, for your full description of the Catawba Indian case. It'll help out our history of Tega Cay no end. Thank you.